sorry about that, guys. Hey, my name is Debbie. Welcome to my channel. I usually feed her after the stream starts, but she was sitting down here begging, and it would have gotten very annoying. You guys, I am super dizzy this morning. The room is spinning right now. So, I can't concentrate while I'm spinning. There was a really interesting thread on X this morning, something that Mark Federow said about the Brian Walsh plea. Nate the lawyer went into surgery this morning. I don't know what time he posted that. 8:02 a.m. Oh, so he just posted it. Said, let's go. See you guys in 6 to 10 hours.
You can move faster in it.
You guys, I'm so dizzy this morning. Don't mess with me. Probably have fluid in my ears from that cold I had last weekend. Chandler's statement at sentencing. Your Honor, I want to take this opportunity to state my intent to appeal my convictions. If there are any lawyers listening and willing to take on my appeal, take a moment to please reach out for me. It's not that I do not have feelings, it is that I was warned to not show them due to the scrutiny of this case. It's a pretty good sentencing statement. Good morning, Judy, Jennifer, Marty. Jennifer's the only one that loves me. Wiggles.
Come on, Sage, let's go out. Come on.
You guys are so mean to me. Well, I don't know where the...
You're hungry, son. Eat that.
Oh, wait, there it is. Feel obligated to point out what should be obvious regarding Brian Walsh's plea. Yes, it's a smart move by his attorneys. It may deflate the impact of impossible to discredit evidence regarding his efforts to dispose of the body. But don't think for a minute that evidence of his motive will not be used against him, alongside his conduct that he pleaded guilty to with a proper instruction. Not to mention it is absurd that a mystery person killed Anna. He then searched on how to dispose of her and did so. But this is hardly a game changer. The prosecutor, yes, even in Norfolk, is no dummy. He'll make the obvious common sense point, if not Walsh who. So I guess he's going for a, yeah, I disposed of her body, but I didn't kill her. And, the first comment is so good. I thought you could throw a different timestamp on Google searches to make them irrelevant. Maybe Brian Walsh searched that in 1983 for a science project and the tab was still open when his wife got killed. So anybody that was here for Karen Reed gets that reference. But so I found this extremely interesting because as I read the comments, someone said, I have watched Melanie Little a little bit, but not a whole lot. I've not watched any of her Brian Walsh coverage. And somebody says, Melanie Little says, Anna might still be alive. So I didn't know that was even a theory. And then, I guess she was having an affair because somebody else said Anna's lover's wife had a motive to kill her. And someone else said something about somebody else said, do we know where Colin was? Just asking. And there's a picture of Dave Chappelle. But then someone said, didn't his own mother hire someone to spy on Anna without his knowledge or explicit request to do so? Sounds like mother puts her nose where it doesn't belong when it comes to her son's personal life. So who's to say she didn't ambush Anna herself or hire someone else to do it? Now, this is Charlie. I was just gonna say, that reminds me of another mother that we've heard about. But see, I didn't know any of this because this is another case that I wanted to come into the trial fresh. And this, now I'm intrigued. I'm like, but he's already pled guilty to some stuff and he's been incompetent. And I'm so afraid this is going to be like another, what was the other one we wanted to watch so bad? Oh, Brian Koberger. And then he pleaded. And so now I'm like, crap. I'm so afraid now because he's pleaded guilty to some and not guilty to others. And I'm like, this is going to end up being another one where it doesn't go to trial. Hopefully it goes to trial. But so I saw that this morning and I was like, oh, interesting. This is going to be a good one if it goes. So we'll have to wait and see. So it's supposed to start December 1st if there's no more continuances. So I can't wait to get my stupid tripod. I can't, like, I'm trying to talk to it, and then but I can't see, so I can't keep myself in the frame and then watch chat. I feel like I'm failing you guys. Now the sound is an issue, and then yesterday, the monitor wouldn't turn on, and I was like, oh crap, now I'm gonna have to go buy a new monitor too. Oh, good gravy.
Simply the first paragraph starting with the description of the judge who wrote the decision, just that entire first paragraph, and stopping at where it says background.
Is it from the opinion or is it the editorial summary?
It appears to be the editorial summary at the top.
Any objection?
No objection.
Okay, it may be read.
And so I'll have you start with the name Peter Capuzzo and read from that point forward. You do not, I think it's okay if you do not read the statutory numerical sections as you go through it. I think
Thank you.
that would be hard to understand.
Peter Capuzzo was convicted of first-degree intentional homicide and hiding a corpse with intent to conceal a crime. The prosecutor presented evidence that Capuzzo killed his cousin, Wivano Mushambe.
You can use initials.
Capuzzi, M.M. Capuzzo, cut up her body and disposed of the parts in the Wisconsin River. Capuzzo argues that the trial evidence was insufficient to sustain his convictions and that evidence relating to a trained dog, which allegedly detected large amounts of human blood residue in Capuzzo's apartment, was improperly admitted. We conclude that the evidence was sufficient to support Capuzzo's convictions and that any error in admitting evidence related to the dog was harmless error. We affirm the convictions.
So when we talk about the Capuzzo decision, going back to Exhibit 449,
She's in the mood this morning.
9:45 in the morning on the 8th of July, correct?
That is correct. It was at 9:45:08, yes.
Now, in this case, I think you started, we asked you what you did for a living, and you mentioned that part of your job is mapping and timelines and things of that sort.
That is correct.
We talk about mapping, we talk about cell phone mapping.
That is correct.
Is that something you regularly do in your job?
It is probably the most common thing that we do.
Okay. In cell phone mapping, you're concerned with tower records, cell phone tower records?
Yes.
Okay. Talk to me about how cell phone towers work.
Typically, there are 3 sides to a tower, and the side of the tower that's used is going to be the strongest tower that the phone chooses to be able to support a communication. So when we get phone company records back, it gives us a side of the tower that was used that gives us directionality for possible travel and things like that. They typically keep records, the cell phone companies typically keep records for their own business purposes, who people are communicating with, the times that are used, how long the communications last. And they keep all of that so they can provide better support to their customers. The tower ranges typically for 3 to 5 miles, but it can cover as far as up to 10 miles, depending on the area, what the population is, what the needs are of their consumers. So in more urban areas, you're going to have less coverage, but you're going to have many more towers. Then in rural areas, you're going to have fewer towers that have much larger coverage areas.
When it comes to cell phone records, do you need to activate your phone? Do you need to do anything affirmatively on your phone throughout the day for it to be connecting to cell phone towers?
Not necessarily.
Tell us about that.
So throughout the day, the carrier is constantly sending updates to your phone to figure out where you might be. Your phone may be reaching out to get updates for different applications that might be utilized on your device. But your phone is always reaching out to figure out what tower is going to provide the best strength and the best support for the next communication that you choose to make.
Do sometimes in a very short period of time, do sometimes phones connect and reach out to multiple towers?
That is correct.
And in those cases, you're able to determine directionality and distance based off 3 different locations or 2 different locations?
Possibly, yes.
And does that assist you in providing a perhaps more precise location of where someone is?
It can.
Okay. Cell phone tower data itself is an approximate location, or is it an exact location of where someone is?
It gives a general side of the tower that's utilized for a communication. So again, that coverage can go anywhere from 0 to up to 10 miles, depending on that particular tower. So it generally gives us a side of the tower that is used.
Is it always the same? If you and I both have Verizon and we're sitting in this room together right now, is it always the same exactly whose phone's connecting to what tower in an urban area?
It should be.
Does it always work out that way?
Not necessarily, no.
Okay. Sometimes when looking at cell phone tower records, do you see towers that are maybe way off in the distance blink on for moments and then go away and never be used again?
I do.
What does that mean, or what does that look like?
It could jump back to an earlier data session for a moment, or it could be that the tower really isn't the best, to support that connection. So then it jumps off to a different tower to maybe handle the rest of that communication. More often, we see that with data records.
In this case, the relevant phones of Bart, Krista Halderson, Chandler Halderson, and even Chandler's brother Mitchell, that was all U.S. Cellular?
That is correct.
Okay. And U.S. Cellular tower data was collected via subpoena and provided to you in this case?
It was.
And I'm showing you exhibits number 438, 439. What does 438, the top one, appear to be?
It is a certificate of authenticity from U.S. Cellular.
And is that what they provide when they turn this data over usually?
It is.
And 439?
It is a USB drive that is labeled U.S. Cellular phone records.
I'll move 438 and 439.
No objection.
They are received.
When these records are received, are they in an easy to view fashion, or do you have to do something to them to make them, to be able to comprehend what they're saying?
U.S. cellular records are a little bit tricky. They do come in an electronic format, so they're easy to open up, but you do definitely use the training that you have received over the years to be able to interpret those records a little bit better. The most common thing to do is to adjust the time zone so they're all in central time.
Sure. And you said mapping at the beginning. What do you do? What does that mean to you when you take tower records and you're going to map them? What is that?
So we have a list of towers that are provided by U.S. Cellular that lists all of their tower locations and the degrees which each sector of the tower covers. And when we match up the phone records, we use the tower that they provide in the phone records and match it up to the tower list and just connect it to the same tower name. And then we're able to use that latitude and longitude and the sector that's indicated to determine how it's mapped out.
And when we talk about the map, what is the map? Is that your own created map, or what map do you use to overlay this data onto?
The map layer that is shown most commonly is Google Maps. And we can change that to reflect satellite imagery, where you see the roads and the landscape, trees, and such.
When doing mapping, do sometimes you use Snapchat records,
Yes,
specifically Snapchat location data?
yes, we can.
Talk to me about Snapchat. When you're talking about mapping, we talked about cell phone records. What does Snap add to the puzzle sometimes?
So Snapchat users can select whether or not they want to share their location with all of their friends, some of their friends, or no one. And when you do that and you open up your Snapchat to actively use it to message or post a story, whatever you may be choosing to use, Snapchat is collecting your location information. So anything that has a latitude and longitude provided with it, we can generally add to our maps with the cell phone location data.
Is this data more precise or less precise than cell phone tower records?
It is more precise.
Sure. Is it always exactly spot on?
No.
Tell me about that.
So there are areas of accuracy with any precision locate. So even if you open up your phone and you open up your navigation app, it may show you off the road. So there's always an element to you drifting off of where you actually are. And it's based off a number of things. And that can include the number of satellites that are used in the area, if there are any blockages or obstructions, like trees, buildings. And it can also depend on how your phone is connected to the network as well. If you're connected to a Wi-Fi network, it's gonna be more precise because Wi-Fi networks are small and therefore you have to be closer to it to be able to connect. So more precise.
When you map Snapchat records, if we think of it as like a dot on a map that you're pointing down, do you ever come across records where those dots will be in one location and then you'll see a random one way off in the distance, which maybe couldn't exist unless someone was teleporting there, and then it appears back at the spot it's been the whole time? Have you ever seen that?
Yes.
What is that called, or what is that?
It's something that's referred to commonly as drift. And so again, it just, depending on how well connected your phone is to the network or how visible it is to the satellites or different ways that it's using to narrow down your location, you could drift away from where you actually are.
For that reason, is it important to look at the number of times that Snap is locating or updating your data into the system?
That is correct.
Okay. So did you obtain records from Snapchat in this case regarding the location of Chandler Halderson's Snapchat account or his phone that was connected to that account?
I did.
And is that certification exhibit number 440?
Yes,
And does 441 appear to be the USB containing those records?
it does.
If you could for me, on 440, on the second page, are you able to identify the username that this file was in regards to?
It is related to the Snapchat account Chazzle Dazzle.
I'll move 440 and 441 into evidence.
No objection.
It is received. They are received, I should say.
Thank you. So we talked a lot about the cell phones and we talked about Snapchat. You did do some mapping in this case.
I did.
Okay. Showing what's been marked in this case as exhibit number 573. What does that appear to be?
This is the work product that I created that shows the summary of all of the mapping
Okay. And is 436 essentially a container for the USB containing that map?
Yes.
All right, I'll move 436 and 573 into evidence,
No objection.
They are received.
and I'd ask to publish.
You may.
I'll need the lefty.
HDMI.
The screen in front of you is going to come on. We're going to be able to look at some images together. Let's see if we can't look at this in the best fashion. All right. So let's just talk about this first page. What are we looking at there?
This is just my introductory slide that shows a list of all of the telephone numbers that I reviewed. The tags indicate that there is a chronological report associated with that. And it gives the refresher that sectors are represented by that pie-shaped icon and that they're drawn out to represent 1.5 miles. That's not necessarily the area of coverage by a particular tower. It's just for visual representation. And there's also a notation that the device that was used by Bart Halderson had no outgoing communications or data records associated with it after approximately 2:30 p.m. on July 1st, 2021. The device used by Krista Halderson had limited activity on July 2nd and was active for a short time around 11:02 a.m. on July 4th, 2021, which corresponds with a text message exchange.
Excellent. And so as we go through this, when we see that the sector symbol or that pie-shaped icon, we're talking about that directionality from the tower that you talked about?
That is correct.
When we talk about, and eventually we may get to data from Snapchat, how is that depicted on these maps?
There will be a legend that indicates it's going to be a circle shape.
Okay. And you were asked to look into July 1st, 2021, all the way through the date of Mr. Halderson's arrest on the 8th.
That is correct.
Okay. So let's start on July 1st of 2021. We'll walk through this slide if we could. What are we looking at there?
You can see the legend on the left-hand side indicates the colors associated with each individual's phone records. This shows all three phones for the duration of July 1st. You can see that the red and the green sectors representing Bart and Chandler, and the small circles, they're kind of clustered together near the icon for the residents. Those all seem to stay somewhat stationary, but you can see that the purple sectors travel down to the Madison area, between the residents and the Madison area.
Understood. And so when we look at this piece of data, there's a notation and where all of those clusters are at the very top, just top center. It says Bart and Krista's residence. Is that one of the locations that you were provided to map out that was important in this case?
I was,
And there's a couple of those, are there not?
yes.
And you were provided that information by detectives?
Yes, I was.
Okay. Some of these are, we're going to look at animated maps. Tell us about what an animated map is when we talk about cell phone records.
So what that allows us to do is look at the records as they occur in somewhat real time. So it plays them along so we can see the context surrounding those locations before and after and where they go in between.
And when it came to picking which time periods to map out, you worked with detectives and me, essentially, to figure out which ones were maybe more relevant?
Yes.
Okay. I'm going to click on, see if I can do this right. So here we have an animated map on July 1st, 2021 from around noon to midnight, so the last 12 hours of the day. And are we going to see all of these folks, Chandler, Krista, and Bart, are we going to see their cell phones when we look at this?
Yes.
Because it's the first one we're looking at, I'm just going to ask you a couple questions. That purplish color at the bottom, is that Krista Halderson?
That is.
And the green, is that Chandler Halderson?
It is.
And here he's near his residence, essentially.
Yes.
Okay.
And the red that showed up, that was Bart's device. And you can also see that the towers that they utilize the most when they're at home bounce between 2 or 3 different sectors of various towers. And those provide the best coverage at that time for those communications.
And Mr., the timestamp that's in those sectors, is that in fact the actual time that those records are from?
Yes,
Okay, so we're now moving to 4:20 p.m., 4:30 p.m. around this time?
yes.
Okay.
And fairly soon you will start seeing Krista's phone utilizing towers that end up covering her residence. And again, you can consistently see that the Snapchat locations and the cell phone tower usage is consistent with the devices being at the residence. And we're getting close to 9:00 p.m. And 10:00. $11. And that was the last location.
Going to the next map, we're still on July 1st of 2021. What are we looking at here?
Because that first map showed all 3 phones for the same time frame, I split them out. So here we can see a little bit closer up view of Chandler's location records, whether they're the Snapchat, which you can see a little bit clearer as the small circles, and the green sectors.
When you talk about the Snapchat circles, it's our first time maybe getting a closer look at them. Are they just underneath the little icon for Bart and Krista's residence?
Yes, they are.
And there's a cluster there.
Yes,
Okay. And so is this Chandler throughout the day?
it is. So it shows consistent data session tower coverage from about 12:29 a.m. through 11:17 p.m. There are a few calls that took place, including an incoming call from Krista at 3:19:39 p.m.
Going to the next slide, we're still on July 1st. I think you said you were going to separate folks out. Is this Bart?
This is Bart.
Okay. And what's notable about this slide, or what can you tell us?
So as it was summarized on the first slide that I read over, there is no cellular activity related to this phone number or this device after 2:33:32 p.m. Otherwise, it shows consistent usage throughout the morning into the early afternoon, with data sessions starting as early as 12:40 a.m. And you can see that there were 3 phone calls that utilize these towers.
Next slides, now we're on to just the isolated view of Krista on July 1st. Tell us what we're looking at there.
This one shows very clearly the movement of the phone down to the near east side of Madison from the home. So you can see that she left the house around 7:29 a.m. and arrived approximately 10-ish minutes later, starting to utilize some of those towers off of Highway 151. And you can see that that tower was consistently utilized until 4:56 p.m. And then there's the travel back to the residence with the data sessions picking back up at 5:12:33 p.m. and utilized close to midnight.
despite the phone being used, you're not able to tell in your work who was using the phone after 5 p.m. that night?
That is correct.
I asked you to put Mitchell Halderson on this slide, correct?
You did.
And Mr. Halderson was the whole day nowhere near the residence?
That is correct.
Going into the second, tell us what we're looking at here.
It's the same sort of pattern, a lot of usage around the residence. There is one change in it that the tower to the south is using the western side of the tower to support communications or data usage in this particular instance between 7:07 and 7:22 in the morning of July 2nd. But the rest of the tower activity is consistent with being at the residence or near the residence
For the entire day.
for the entire day.
The one data session that occurs that you were able to map, it's from 7:07 a.m. to 7:22 a.m., the one that's a bit farther away from the house. The Google overlaid street map lists some businesses, does it not?
It does.
And what businesses directly in the center of that sector?
Fleet Farm.
Again, sticking with July 2nd, what are we looking at there?
This is the activity for Krista's phone on July 2nd. You can see that there are no longer data sessions related to that device after 6:41 in the morning.
Again, same question, you're not able to tell who's using that device at that time?
That is correct.
Same question as before, I asked you to just throw Mitchell Halderson's location on there. Again, he's in the Verona area that whole day?
That is correct.
Let's talk about July 3rd. Saturday, July 3rd, 2021. What are we looking at here?
This one is a little bit busier, and it covers just from midnight until noon on July 3rd. And the way that this kind of plays out is that there's a lot of activity around the home until about shortly about 9 o'clock in the morning. And then the phone travels down along the lake near Madison, heads up northwest. And there are some data sessions around that area that has a box surrounding it. And that is activity that occurred from 8:26 a.m. till 9:02 a.m. Then as you follow that around to the north, there is a tower that's utilized across the river, very towards the top of the map, that's utilized for a phone call. And then you can see it shifts back down to tower 550101, and that one's utilized for the next call. And then you can see that the phone then travels back to the residence and then heads actually down to the Madison area from 10:35 until 11:51 a.m. So it's kind of like a big circle.
Sure. And we're going to look at this map a little bit further. But here we only see Chandler and Chandler's Snapchat. Was there any activity from Krista Halderson or Bart Halderson's phone that day?
No.
And nothing would appear on this map?
No.
Okay. And then just so everyone is looking at the map and can see everything, again, you labeled Bart and Krista's residence on that map?
Yes.
All right. The area that has the box around it, the black box, are we going to look at that further and a little bit closer in?
We will.
And is that the area around Prairie du Sac or just north of Sauk City, Wisconsin?
Yes.
Okay. And then just so everyone's reference, that very top tower that only had one entry at one point, that's just south of Devil's Lake?
Yes.
Okay. You were asked to animate from 7:30 to 9:30?
That is correct.
All right, and we'll look at that.
So again, this just shows kind of in real time what these records look like to give more context. And it's probably easier to understand than listening to me try to describe it.
I think you're doing a fine job, but I'll just note, here you've put an additional label on. So we have Bart and Krista's residence labeled, and then there's another label by Prairie du Sac. What does that say?
It says remains found approximate.
And was that the location given to you by detectives?
It
regarding-
was.
Okay.
What is different on this animation versus the static map will be the arcs that are drawn out away from the sector. And those are an approximate distance that was provided by the cell phone company.
In
Does
dealing with this
anybody want a
day still
dog?
on Saturday, July 3rd, that location far to the left, which it appeared that Mr. Halderson's phone moved and stayed for a good period of time in the morning. Did you do some closer up imaging of the tower records as it relates to that location?
I did.
Okay. And tell us what we're looking at here.
So this map shows the towers that cover that particular area and were used by the device. You can see that there's pretty consistent usage from approximately 8:26 a.m. through 9:02:38 a.m. And you can also see that there is an arrow pointing near the red icon, and there are some there's a very small dot in there. That is a Snapchat location, and there are 2 entries for that particular location.
And you mapped that and took out the cell phone data so you could see that more clearly?
I did.
And is that what we're looking at in this slide?
It is.
And if we look at the very bottom of the screen, is that the location where you've been indicated by detectives to place the remains found?
It is.
Again, staying with July 3rd, so again, we're still on Saturday, July 3rd. This is the other half of the day, the afternoon into the evening?
It is.
Okay. What are we looking at here?
This map shows the device traveled up to the Portage, Wisconsin area on the evening of July 3rd. So around
I don't need another
10,
cat either.
shortly after 10:15, the
Getting too old
device
for pets.
started
I
traveling
don't have the
north,
patience anymore.
utilizing towers along the way, and stayed in the Portage area from approximately 10:37 p.m. to 11:03 p.m. And then it returned back to the area of the residence closer to 11:24 p.m.
And you animated this as well?
I did.
All right, let's take a look at that. From 10:30 to 11:30?
Yes.
And again, if you could explain those arcs that we're seeing.
So the arcs are an approximate distance from the tower, and that's the cell phone company's best estimate as to where the device may be. And they give it to us in miles and segments thereof. And so when you have more of them intersecting at a particular location, that gives more credence to their accuracy of that particular distance from the tower. And so you can see as it gets closer to the tower, you can see the lines get closer within the green sector. As the device tends to move away, you can see them expanding out away from the tower, which again, it just gives a little bit more directionality.
Again, you mapped Mitchell Halderson that day. He was in the Verona area all day.
That is correct.
Talk to me about July 4th. What are we looking at there?
July 4th, Krista's phone has activity for the first time in several days, and it's only for a short time frame. The rest of this map is showing Chandler's device usage, where the device seems to travel down to the Madison area, where it stays for just over 2.5 hours, and then it tends to travel over to the Cottage Grove area, where it is from approximately 3:43 p.m. to 6:51 p.m. And then it returns back up to the residence around 7:29 p.m. And again, in the details of the next slide will show what the communications within that black box.
Sure. And we'll go to that next box. Here, you've mapped the residence area on July 4th, 2021, from 11:02 a.m. to 11:09 a.m. Is this the first time, I think you said in several days, you see Krista's phone have activity?
That is correct.
And what can you tell us from this slide? What are we looking at?
This, Krista's particular tower usage was inclusive of some data
Can you
session
behave for
records
5
that occurred from
minutes?
11:02
Give me
to
5 minutes.
11:04 a.m. And this is also where there was an outgoing message to Chandler's device at 11:04:23.
And was that the message listed there? Made it safely, can't get anything through though, and yes, it's packed. Going to White Lake today for the parade and be home Monday night, Tuesday early. Love you lots.
That is correct.
Okay. That message was sent from Windsor, Wisconsin,
It was.
not White Lake, Wisconsin.
That is correct.
Briefly going back to the last slide before we move forward, the location on the bottom right of that screen on the 4th of July from 3 to just before 7. We're going to talk more about that location as we go further in other days, but that's the general location of the Irwin Road Farm.
It is.
Okay. All right. Again, I ask you to map Mitchell. He was in the Verona area all day.
Yes.
Talk to me about July 5th. What am I looking at here?
So July 5th shows the device activity for Chandler's phone. It appears that it was pretty consistent at the residence throughout the day until about 4:30 p.m. And then the device tends to move south along the interstate and heads out to the Irwin Farm address until about 6:54. Then it heads back to the Madison area where it stays for a while. You can see some activity from 7:10 to 8:34 p.m. There's some call activity there. And then it appears to return to the residence around 8:52 p.m.
Bart and Krista, their phone's not active this day at all?
That is correct.
Okay. And you animated that trip down to what you described as the Irwin Road property. You animated that, and it goes from 4:30 to 9 o'clock?
Yes.
All right, we'll take a look at that. So this is again July 5th, Monday.
Spike. What are you doing?
And again, with the arcs, when they start to intersect, that tends to give more credence or more weight to the approximate location of that particular device.
In case anyone's having trouble seeing, would you mind telling us about the time we're at now?
It is about 6:30. And we are approaching 7 o'clock. And you can see the device is starting to head away from that Cottage Grove area. And we're at 8 o'clock.
I don't know what you want. It's an empty bowl, Spike. Good Lord.
And as we approach 9 o'clock, it appears that phone ends up back at the home.
Yes.
Same day, we're still on Monday, July 5th. What are we looking at there?
This is a particular time frame of noon to 4 p.m. on July 5th. And it shows that the device is consistently at the residence with data sessions active pretty consistently from 12:05 p.m. to 3:59 p.m.
Sure. And in fact, just to be clear, I'm the one who asked you to put this map together?
Yes.
Okay. Showing you what's been marked in this case and received as exhibit number 536. You may not have seen these before, but these appear to be text messages between someone named, what is the top?
Hubby
And who?
and Catherine.
All right. And I'll represent to you that it's been testified in this case that these are messages between Chandler and his girlfriend. Just briefly, could you read through the first couple of pages of those and you can just start with the start time there and then read through?
July 5th, 2021 at 12:35:05 p.m. The message says, 1 sec. The response from Catherine at 12:35:08, okay, okay, then another response at 1:31:46 p.m. Text me when you get to your appointment. The message from Chandler says, yes, dear. That is at 1:32 and 30 seconds. The response from Catherine at 1:33:25, good boy. The response from Chandler at 1:40:09 p.m., thanks, B. The response from Catherine at 1:40:24 p.m., 1:40:26, I love you. 1:40:30, it's gonna be okay. 1:41:05 from Chandler. Either way, you and me are gonna be happy. 1:59:37 from Catherine, very true. Response from Chandler at 2:01:53, made it a bit ago and checked in. 2:01:56 from Chandler, BRB. 2:09:12 from Catherine, you got this, B. 2:18:56 p.m. from Catherine, yeah, question mark. 2:19:18 from Catherine, am I picking you up? I'm off at 5. 2:20:19 from Chandler, just need you to know because I have horrible reception. And that same message is resent at 2:22:10 p.m. At 2:22:43 from Catherine, okay. At 2:22:52 p.m. from Catherine, do they gave Wi-Fi? At 2:23:07 p.m. we can snap if that's easier. At 2:23 p.m. from Chandler, no connection to even load Snapchat. At 2:23:42 p.m. and no Wi-Fi. 2:23:54, but I can still get your iMessages. At 2:24:17 from Chandler, no connection to even load Snapchat. 2:24:17 p.m. and no Wi-Fi. From Catherine at 2:24:34, that's good. 2:24:42 p.m. from Catherine, and weird that they all gave it. 2:24:46, have it. At 2:24:54 from Catherine, but maybe it's your carrier. From Chandler at 2:25:26, I'll try and get it on. And that message is received or resent at 2:27:18 p.m. At 2:31:21 p.m. from Catherine, let me know what happens. At 3:25:08 p.m. from Chandler, hi hun, 3:25:10, heading home. 3:25:48, they took an x-ray and CT scan, nothing bad on the x-ray.
All right, and I appreciate you doing that. And just clarity of the record, we're talking about exhibit number 536, and just confirm the date again for
It
me.
is July 5th, 2021.
Essentially in the afternoon.
That is correct.
Did you perform an animation between 12 and 4 p.m. on that day?
I did.
Let's take a look at it. If you could read off the times as in increments, if you could.
So we're approaching 12:30. One o'clock. Two o'clock. 3 o'clock.
The phone stays in the same general vicinity as the residence during that time period?
Yes.
Going back, because again, we're staying on July 5th. In the bottom right corner of this overall map of Mr. Halderson's locations on July 5th, there's a square. Is that around the Irwin Road property?
It is.
And were you able to look at that a little bit closer for a trip out there in the afternoon and into the evening of July 5th?
I was.
We'll go ahead. What are we looking at there?
This specifically shows only the Snapchat locations that occurred during that particular time frame. You can see that they start around 6:08, 16 p.m. And the last one on the screen is at 6:53, 32 p.m.
And I think we talked about it earlier, but I'm going to draw your attention to something specifically here. In the Snapchat list of data points here, for instance, there's the first one, which is at 6:15, 42 p.m.
Yes.
If we look far right across that big farm field, and another farm, it looks like, at 6:15 and 28 seconds, so just 15, 20 seconds before, there's a couple times where it hit right there.
Yes.
What do you believe that is, or do you have any opinion as to what that looks to be?
It could be an example of the drift. It's claimed, the accuracy on it is fairly good, but again, it can be the accuracy of the overall location itself can be thrown off due to various things, obstructions from buildings or trees, the lack of, possible satellites that are around, what kind of connection it has, the device itself has to some sort of network, whether it's data or Wi-Fi, things like that can throw it off.
So on 3 different occasions on that farm on the right, there appeared to be a data location that came through.
Yes,
And you put that on the map
yes,
because you put everything on the map that you got.
those are the records.
Okay. On the far left, there's more Snapchat locations on that side.
Yes,
Okay. And did you zoom in on that side?
I did.
All right. Tell me what we're looking at there.
So this, again, is just showing up a closer satellite view, so it adds more context to where the locations are. You can see that there are several locations associated with the circle to the south on the map. Several of them are kind of stacked up in between each other with varying levels of degree of accuracy associated with them. And it takes part in kind of a small time frame, within a matter of 8 seconds. And then there's one location that's captured on the driveway or just around that area near the driveway at 6:08 p.m.
Do you know, so we talked about cell phone records are constantly maybe reaching out and talking to the phones. Is Snapchat doing the same, or is this when people affirmatively use the app, or do you know?
It's when they're using the app.
Okay. So if Mr. Halderson's Snapchat the app would not have been opened on July 5th, we wouldn't just see these naturally as some sort of handshakes that the system is performing.
Correct. That's my understanding of it.
Okay. And for some clarity's sake, the dot that you put for the Irwin Road farm, to the left of that appears to be an actual blue dot on the screen. That maybe is the swimming pool that we've heard about in this case?
That's what I've been told.
Okay. Again, I asked you to map Mr. Mitchell Halderson. He stayed home all day?
Yes.
Let's talk about July 6th. Tell us what we're looking at there.
July 6th shows the movement of Chandler's device from the residence, and it moves fairly early in the morning. You can see the locations down at the south part of the map near Madison. There are data sessions there occurring shortly after 5 a.m. And then the phone does move back up to the residence where it maintains its location until that evening, where there is a trip down to the east side of Madison area near the interstate, and then it returns back to the residence.
I think you mentioned, and just so there's some clarity, there was you said an early morning trip kind of into the downtown area?
Yes.
What time does it appear that trip, if you had to give a range based on the records that you have?
The gap in the data sessions near the house are from 4:32 a.m. to 5:37 a.m. So it would have been around that time, which matches with the tower location that I highlighted at 5:05 a.m.
Understood. Again, I asked you on July 6th to just map where Mitchell was, and he was home again.
Correct.
On this day, we see a couple of things from Mitchell's phone listed there. What do we have?
There are some outgoing calls to, or one outgoing call to Bart and one outgoing call to Krista.
It's Nancy.
Let's talk about July 7th. July
So-
7th, 2021, Bart and Krista, their phone's not active,
Correct.
and they weren't active the day before.
Correct.
Okay. What are we looking at here on July 7th?
So these records are showing us the movement of the device down out to the Irwin farm. Again, this time it occurs between 9:30 a.m. and 11:30, or I'm sorry, 11 o'clock a.m. Then the device seems to remain consistently at the residence throughout the evening.
And did you animate the trip down to that black square, the Irwin Road area?
I did.
And that's from 9:30 to 11 a.m., and we'll watch that together.
What? Stop it!
That location in that black box down there, Irwin Road, were you able to see some of those sector lines a little more clearly in that location in this mapping than perhaps you always are?
Yes,
Okay. And you did some close-ups of that location?
I did.
All right. So here we're looking at general time period around 10 in the morning. I think the earliest is 9:57, all the way through maybe 10:14 or so. What are we looking at there?
So these are primarily the data sessions that were used during this time by that device. And you can see that there's a number of arcs that kind of intersect all at one point, and that happens to be near the location where I have the marker identified as Irwin Road Farm.
And if we go to the next slide, sticking on July 7th, is that a closer up of that farm
It is.
and those sector lines intersecting?
It does.
On that day, I asked
Wait,
you
let me
to
turn the keyboard off first.
map for Mitchell Halderson as well.
Yes.
Again, he stayed in the Verona area all day.
Yes.
He had some activity though on his phone related to calling Bart and Krista.
Yes.
What times did he make those calls?
11:45, 4:50, 5:47 p.m., 8:27 p.m., and 9:12 p.m.
Moving to July 8th, 2021, the last day that we're going to talk about. Just what are we looking at there?
This shows that the device activity related to Chandler's device, and it remains consistently at the residence up until about 4:15 p.m. There are no records between 4:15 and 7:55 p.m., but then you see the next data session towers that are utilized are down in the Madison area.
And in fact, that tower might be close to where we are right now.
Quite likely,
Okay. In the vicinity of the Dane County Jail.
yes.
Okay. Could you talk to me about Mr. Halderson's activity on his phone that day? I think you have listed in that box on the right.
There were some incoming and outgoing calls to and from Mitchell.
There was outgoing at 10:10 to Mitchell, incoming at 12:58, and outgoing at 4:12.
Yes,
And then there were two other outgoing calls that day.
yes,
And if the jury's heard evidence in this case that two calls were placed to law enforcement officers that day, would that account for two possible calls that were outgoing that day?
it's possible.
Okay. I asked you to map Mitchell Halderson that day,
Yes,
and he did some stuff that day.
yes.
Where does he appear to go?
He went north, likely up to the area of the cabin that Krista and Bart had. He left his general residence area shortly after 1 p.m., stopped near Bart and Krista's residence about 1:45 to 2:06 p.m., and then traveled up north. You can see the tower that's highlighted there was utilized from 5:17 p.m. until 6:24 p.m. And then the device
Let me break this stuff
goes back
down.
to the Bart and Chris's residence and starts utilizing data session towers down there from 9:52 to 10:50 p.m.
Understood. And if you could you just detail the time that Mr. Mitchell Halderson made calls to either Bart or Krista that day?
Yes. Started at 6:37 a.m., 12:15 p.m., 6:24 p.m.
And to just compare, just to go back, just to confirm, did Chandler Halderson on July 8th make any calls to his parents?
No.
No further questions?
Cross-examination.
Thank you. Analyst Rep, I want to ask a few questions about those maps we just saw. First of all, am I correct in understanding that those maps track a phone, not a person?
Correct.
So when the district attorney asks you a question, like that map shows Mitchell in Verona, really the question is that map shows Mitchell's phone in Verona, correct?
Yes.
And the second thing I wanted to clarify about those maps, at various times during your testimony, you were asked, you don't know who was using the device after 5 p.m., and your answer was no. Do you recall that kind of question?
Yes.
Is it accurate to say you don't know who was using the device before 5 p.m., if that were the question, correct?
Yes.
You don't know who's using these devices
Correct.
at any time.
Correct.
Now, going back in time to your testimony before the maps, I want to clarify the Google Records exhibit. Do you recall that exhibit?
I do.
And so that exhibit would show, for example, a search query such as Wisconsin dismembered body found. Do you recall that?
I do.
Did that exhibit then show if the results of that query were clicked on?
The only thing that would indicate that would be the follow-up article, as in the example of the state versus Capuzza.
So that could have come up as a result for that initial query, correct?
Correct.
That exhibit isn't saying that someone searched state versus Cupaza.
Correct.
And finally, relating to the Google records again, I believe your testimony was that you obtained records from sometime before July 1st through July 8th. Do you recall saying that?
I recall being asked that.
And your answer was yes.
Yes.
How much in advance of July 1st did you get these records?
I believe that there were several search warrants that were done for the various Google accounts. And I do not remember the exact time frame for any one of those in particular.
But for some period before July 1st, you obtained these same types of records for Mr. Chandler Halderson's Google accounts,
Yes,
where someone could have seen what types of things he searched, correct?
correct.
Same as they did after July 1st, correct?
Correct. To clarify, the report that I had was for that entire duration. So on those days prior to those particular searches, there was no history of what had been searched other than in YouTube.
One moment. Whoops, wrong exhibit. So it's your testimony that all the records you found for Google records before July 1st, the only search terms used were YouTube search terms?
I would have to double check in the original records to look prior to July 1st.
Do you have those records with you?
I do not.
Okay, thank you.
Can you redirect?
You were specifically asked in this case to produce records and mapping regarding the time period in question, the first, which corresponded to the last time Bart Halderson, Krista Halderson were known to be alive, through the 8th, which is the time of arrest.
That is correct.
And just to clarify, we talked a little bit about there not being records for certain days. We talked about the July 1st, July 2nd, July 3rd, July 4th, July 5th, and July 6th. We talked there's only YouTube records.
Correct.
YouTube, while owned by Google, is a separate location if you want to erase that history.
Correct.
Okay. So one could go into their Google account, erase that history, and that would not erase your YouTube history.
Quite possibly.
Okay. And I think you testified earlier, you're not here to comment on whether those were deleted or whether they just didn't happen on those days.
Correct.
The time periods and things of that sort that were relevant, those are all information provided to you by the police and people involved in the investigation. That was areas or times that they wanted you to map on these records.
That is correct.
Okay. No further questions?
May this witness be excused and released.
Yes.
Thank you so much. I don't think you have any exhibits there?
No.
All right, thank you for your time. Let me see the attorneys up at the bench, please. this is going to be the point in time where we release you for the evening. We've been through quite a bit today, and this has been a taxing session because we started, I think, at 2 o'clock with the testimony that just finished. So I appreciate your time and patience today. We've been in and out of here a little bit more than usual. We'll start tomorrow morning as usual. Get a good night's rest tonight, and certainly follow the admonition to not discuss the case or be exposed to any information purposely or inadvertently as we begin to get closer to the finish of our case. Do get rest, take care. It's supposed to be really cold, so maybe stay inside and huddle down and have a good quiet evening. We'll see you tomorrow morning. Thank you.
All right, the jury.
Please be seated, everyone. Good morning, ladies and gentlemen. I'll inquire of you whether anyone was exposed to any discussions about the case or engaged in discussions yourself with anyone, including yourselves, about the case, or did any research, looked up any information, or sought or was exposed to any media reporting about the case. I see no hands. Thank you so much. As a housekeeping matter, we have an exhibit numbered 1000. There have been stipulations about facts, which I've read to you during the course of the trial, and these have been reduced to writing and have been marked as an exhibit so that they're formally within the record in written form, and the state and the defense agreed that I should mark this as an exhibit and be received into evidence, correct, Attorney Brown?
Correct.
And Attorney Doral?
Yes.
It is received. Attorney Brown, does the state wish to call a witness at this time?
No, at this time, the state rests its case.
Thank you. Attorney Doral, is the defense presenting testimony at this time?
The defense rests as well.
Then, ladies and gentlemen, the evidentiary portion of the trial is closed.
Oh
and so
my
should your
God,
notebooks.
I didn't expect that.
If you can close those up and set them on the floor, once we have finished here in this room, those of you who are not in the end chosen as alternates can pick up the notebooks and take them with you to the deliberation room. Those of you who are chosen as alternates, when we go through that process, can leave them on the floor, and those will be collected and destroyed. I'm going to start the process of closing out here in the courtroom by reading to you the final jury instructions. There's a number of pages, and some of this is familiar to you because I know you paid attention when I read the preliminary jury instructions, and there is a degree of repetition. I will advise you that in preliminarily instructing you, I did combine the counts so that instead of reading instructions for 8 counts, I read 4 with references to the 2 separate counts. I can't do that at this point. I need to instruct you on each and every count, so that part of these instructions is essentially doubled. But the purpose of these instructions are to advise you of the law and your role in going forward into deliberations. And you will have these instructions with you when you deliberate in the event you need to reference or look up something that I read to you. So I always want people to know that. You don't have to listen to these thinking I have to remember each and every individual piece of this. You will have a reference point when you are deliberating. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case, which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdicts. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. I remind you that in this case, the district attorney and the attorneys for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. Exhibit 1000 is a written copy of those stipulated facts. Count 1 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did cause the death of Bart A. Halderson with intent to kill that person, contrary to Wis Stat 940.01 sub 1A. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant caused the death of Bart A. Halderson. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Bart A. Halderson. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Bart A. Halderson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Count 2 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021, in Dane County, Wisconsin, did deliver written and or oral communication with intent to induce a false belief that the defendant had knowledge of the whereabouts or physical condition of a missing person, Bart A. Halderson, contrary to section 946.48 sub 1. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means that the state must prove every element of the offense charged beyond a reasonable doubt. Section 946.48 of the Criminal Code of Wisconsin is violated by one who sends, delivers, and/or causes to be transmitted to another any written or oral communication with intent to induce a false belief that the sender has knowledge of the whereabouts of a missing person. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant sent, delivered, or caused to be transmitted a written or oral communication to Dane County Sheriff's deputies. Number two, the defendant did so with the intent to induce a false belief that he had knowledge of the whereabouts of a missing person, specifically Bart A. Halderson. This means that the defendant had the mental purpose to cause Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person, specifically Bart A. Halderson, or was aware that his conduct was practically certain to cause Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person, specifically Bart A. Halderson. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent. If you are satisfied beyond a reasonable doubt that the two elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 3 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and/or between July 1, 2021 and July 8, 2021, in Dane County, Wisconsin, did dismember the corpse of Bart A. Halderson with the intent to conceal a crime, contrary to Stat 940.11, sub 1. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11, sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant dismembered a corpse. Number two, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 4 of the amended information alleges that the above-named defendant, Chad M. Halderson, on and/or between July 1, 2021 and July 8, 2021, in Dane County, Wisconsin, did hide the corpse of Bart A. Halderson with the intent to conceal a crime, contrary to Stat Section 940.11, sub 1. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11, sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant hid a corpse. Number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 5 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021, in Dane County, Wisconsin, did cause the death of Krista R. Halderson with intent to kill that person, contrary to Wistat Section 940.01, sub 1, sub A. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of this offense, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following two elements were present. Number one, the defendant caused the death of Krista R. Halderson. Cause means the defendant's act was a substantial factor in producing the death. Two, the defendant acted with the intent to kill Krista R. Halderson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Krista R. Halderson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Count 6 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021, in Dane County, Wisconsin, did deliver written and or oral communication with intent to induce a false belief that the defendant had knowledge of the whereabouts or physical condition of a missing person, Krista R. Halderson, contrary to Wistat Section 946.48 sub 1. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of this offense charged beyond a reasonable doubt. Section 946.48 of the Criminal Code of Wisconsin is violated by one who sends, delivers, and or causes to be transmitted to another any written or oral communication with intent to induce a false belief that the sender has knowledge of the whereabouts of a missing person. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant sent, delivered, or caused to be transmitted a written or oral communication to the Dane County Sheriff's deputies. Number two, the defendant did so with the intent to induce a false belief that he had knowledge of the whereabouts of a missing person, specifically Krista R. Halderson. This means that the defendant had the mental purpose to cause Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person, specifically Krista R. Halderson, or was aware that his conduct was practically certain to cause Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person, specifically Krista R. Halderson. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that the two elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 7 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did dismember the corpse of Krista R. Halderson with the intent to conceal a crime, contrary to Wistat section 940.11 sub 1. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number 1, the defendant dismembered a corpse. Number 2, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 8 of the amended information alleges that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did hide the corpse of Krista R. Halderson with the intent to conceal a crime, contrary to Wistat section 940.11, sub 2. To this charge, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number 1, the defendant hid a corpse. Number 2, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from a defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdicts, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to decide whether the state has overcome the presumption of the defendant's innocence and proven the defendant guilty beyond a reasonable doubt. An amended information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence, whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard that suggestion. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness expert's opinion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdicts in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdicts according to the evidence under these instructions given to you by the court. This time I will invite the state to present its closing argument.
And is HDMI left on, Your Honor? Okay. HDMI left on, Your Honor? Okay. Good morning. I always start my closing arguments in the same way. And it's simply this. If any of the attorneys, either throughout the trial or during closings today, from either side, myself, Mr. Brown, or the defense, misstate a fact or evidence, you should go with your collective memories. You guys are the jury. We've sat with this case for months, had meetings about it, talked about it, read things about it. And sometimes, not intentionally, but sometimes people, misremember something or think of one thing they read. So please use your collective memories as jurors to determine what you heard and what you saw. Additionally, it should be the written law that the judge just read and that you will get a copy of that should determine how you process and think of the law. For years, I've listened to attorneys where prosecutors have basically belittled the burden of proof and where the defense has built it up to be something that can never be overcome or could only be overcome by video. Neither of those things are true. You should look at the written law and follow the written law. Second thing I want to say is I want to apologize for all the graphic photos that you folks had to look at the last 3 weeks. I'm sorry I had to show them to you, but we had to. They were part of a crime, and because of the charges and what we have to prove beyond a reasonable doubt, it was necessary for you to look at some of those photos. I will promise, though, today I will not be showing you those anymore. There will be none of those photos in my closing. So every case that comes in is kind of like a puzzle. You have to look at it because obviously you weren't there. But, solving a case and thinking about whether or not a person is guilty or not guilty is like putting together a puzzle. And it's your job as the jury to put that puzzle together. But the question in this case, or why this case is kind of unique, is the person who committed the crime had 8 days to spread the pieces of that puzzle all over the state of Wisconsin, or at least southern Wisconsin. Now, what are the pieces of those puzzle? They're evidence. What is evidence? It's what you saw in this courtroom and what you heard in this courtroom, testimony. People sitting on the witness stand and telling you what they knew. Before we start off going through that evidence, I want to remind you of the background of the events before July 1st of 2021. In June of 2021, Bart and Krista Halderson lived at 4595 Oak Springs Circle with their son, Chandler Halderson. And at that time in June, they thought that their son had an internship with American Family. Although there was problems with the payment, he hadn't been working there about 6-7 months, hadn't been paid yet. They thought their son was attending MATC, that he had already earned a solar certificate there, and that he was enrolled in the IT program and was one class away from graduating. They also thought that he was going to soon be going to a job in Titusville, Florida at SpaceX. Now, things became a little suspicious to the father, Bart Halderson, who's an accountant. He's wondering, why is a Fortune 500 company not paying my son when he's working there? And for over a year, he was talking to various people at Madison College or MATC about why he hadn't gotten his son's transcripts, why they couldn't get a meeting, why he hadn't received his solar certificate. He had been emailing with these 3 people, Aaron Hoover, Daniel Spieth, and Alyssa Brandt, and been communicating with them. This all kind of comes to a crescendo or to a head the day before Bart is murdered. And on that day, he has a phone call with Omar Job. He starts off this phone call, you can just tell in his voice, he's angry, because he thinks this college has been giving him and his son the runaround for about a year. They're not doing their job. And so he's kind of aggressive at the beginning of this call. You don't really like him until you know the whole story. And he learns during this call that his son has never earned a solar certificate, that his son is not enrolled in the IT program, that his son owes the college over $1,000, and
Adulting is hard. Adulting is hard. Ow! I've missed everything this morning because of adulting. Okay. Yes, punishment shouldn't be making him watch Gossip Girl. I never got into Game of Thrones either. Too much sex. I don't want to watch sex. Oh, thank you, Nancy. Oh, Buffy. Yes, Buffy is a must. Make him watch Buffy. Okay, guys, I am so sorry. I've been adulting. I've been grocery shopping. I've been making doctor's appointments. I've been discussing things with Travis about computer buying. I was thinking about taking this tower back and getting an all-in-one, and talking about buying speakers and headsets and trying to fix this. Ah! Now we're gonna go to the live trial, which is, what's his name? Matthew Lands. And I have no idea if I set it up to read right, guys, so I'm sorry. It's payday, and on payday I have to adult and pay bills and grocery shop, and I don't like it. I don't want to be an adult. Okay, guys, I'll see you over there in a minute.